Very good morning to you, sir. My name is Trishala Sailish. I'm from Symbiosis Law School, Pune, and it is an absolute honor and pleasure to have you with us on this interview. For everyone who is watching, all our viewers, this is Professor Mahesh Deshpande, a man who dons many hats, a medical army officer, a pediatrician, a lawyer, a law professor, and an MA in French, very interestingly. So, welcome, sir. A very warm welcome to you.
Thank you, Ms. Trishala.
Okay. Sir, so first off, I would like to ask you, please tell us about your formative years. What was your environment like? Who were your influences? Your childhood, I mean. Yes.
All right, okay. Well, my father was a judge.
Okay.
And it was a transferable job in the state of Maharashtra. So my formative years were spent at different places. There is a place called Solapur in south of Maharashtra, where the foundations of my primary education were laid. From then onwards, I moved to a place called Buldana and Akola, and then finally in Pune. And I studied in Model High School, Pune.
Okay.
For my SSC. In those days, it used to be 11th SSC. After that, I studied for 2 years in Ferguson College in Pune for my pre-med. And then I studied medicine for 4.5 years in BJ Medical College in Pune.
Mm-hmm.
After graduation from the medical college, I joined Army. And I served for 5 years as a short service commissioned officer in the Army Medical Corps. After leaving Army, I did my diploma in childhood, which is a pediatrics diploma from Armed Forces Medical College in Pune. And after graduating from AFMC, I set up my practice in Pune.
Mm-hmm.
And practiced for a number of years.
All right. Wonderful.
Subsequently, I thought that I must do something different.
Yes.
And so I developed an interest in foreign languages. And I did a year in Russian language, a certificate course.
Okay, wow.
A year in Japanese language, again a certificate course. And then I joined French language, which I studied for 5 years till my post-graduation from Pune University. After that, I wanted to pursue a PhD in French language itself.
Okay.
But then the suitable guide was not available at that time in Pune University. So as a result, I said I must do something again different. So I joined this ILS Law College in Pune here for a 3-year course in law. After graduating from ILS in Faculty of Law, same year, that is 2013, Symbiosis Law School announced a 1-year specialized LLM program, inaugural, with the approval of UGC and Bar Council of India. And so I joined Symbiosis Law School and joined the specialization of criminal law. And I did my post-graduation in 2014. And then for 1 year, I said, no, I'll take a gap year sort of. And in 2015, I joined the PhD program in Symbiosis Law School as a junior research fellow and also a teacher of criminal law. And that's how I have traveled all this way to this stage.
Oh, wow. A true blue polymath, sir. That's what you are. So I want to ask you, what I'm very curious about is you've juggled between a variety of careers. I mean, and you've pursued almost all these heavy duty professions. Like you were an army medical officer, then your pediatrics, and now law. So what steered you towards law at that point post your pediatric career, post that practice? What veered you towards foreign languages and subsequently law? What was it? Was there anything specific?
Yeah, actually, I think I had a flair for languages right from beginning, and at the risk of sounding boastful, which of course I am not, I was fairly good in the language in the school, in all the three. English, my mother tongue, Marathi, and Hindi as well. And of course, I kept on reading in various languages and tried to improve my linguistic skills. So when I thought about doing something different from medicine, the first thought that crossed my mind was, why not do something in foreign languages? And fortunately, in Pune, we have a number of options as far as foreign languages are concerned. And that's how I turned to foreign languages. It was a different kind of a mental stimulus and a very exciting and a fascinating intellectual pursuit, I must say. Mm. And when I landed in French language, I really took liking to it. And then as things shaped up, I pursued with the language till graduation. And then when I scored very good marks for BA in French, then my teacher asked me, why not join the post-graduation? And that's how I did my post-graduation in French. And as I said earlier, had a guide for French language been available for PhD in Pune University, I would have pursued my PhD there. Mm-hmm. And a thought of law would not have entered my mind at all. Mm-hmm. But as luck would have it, I joined law to continue my studies away from French language because PhD was not possible that time. And that's how I turned to law, because I thought that law is a very exciting branch of study. It really, really stimulates you. It involves voluminous reading. It involves critical thinking. And it also involves a fair amount of teaching, which I loved right from beginning, whether it was medicine or French language and now law. I think I simply love teaching. That's how I joined this faculty.
So, thank you for that. Speaking of reading, I remember in one of your classes, you once mentioned that the English, something to the effect of the English language is fancy, it's elaborate, and it's meant to be used in all its glory. What we basically thought you meant to say was use big, big words whenever you can. You know, use elaborate vocabulary, talk, you know, eloquently and fluently. And of course you have it. And that kind of erudition comes from an extensive amount of reading. So to all of those who are watching this video, I would like to ask, what are your reading habits like? How do you keep yourself erudite and sharp and adroit at all times? What are they like?
Well, I love to read right from my school days. And my daily reading included mandatorily the daily newspaper. Mm. Initially, it was in the vernacular Marathi language. When I was in 8th standard, then I felt fairly confident that I can read English language newspaper. And so I started reading English daily from 9th standard onwards, so to say. At the same time, I had a liking to read across various genres. And I remember I picked up my first book, which was in English language, and that was a James Bond novel.
Okay, wow.
And I was really fascinated by the use of words by Ian Fleming, mm-hmm. who didn't have great literary credentials behind him, but he was a clerk in the Royal Navy mm-hmm. during Second World War.
Yes.
But he had that flair for the words, and he had within himself, mm-hmm. which he put it on paper in the form of James Bond. Mm. And I was really, really wonderstruck by the way Ian Fleming expressed. And of course, as you are aware, James Bond is a fascinating character.
Yes, yes.
And then I think I remember my first book was Moonraker, a novel, Moonraker.
Yeah. Yes.
A series which Ian Fleming wrote. And then I really got hooked on Ian Fleming. And I think by the time I joined my first year in college, I had read those main 8 or 10 novels, Goldfinger, Thunderball, From Russia with Love. You know all these titles, the movies.
Yes.
Yeah, Diamonds Are Forever. Mm-hmm. So that was what attracted me towards reading. And then, of course, I kept reading of various genres, plays, poems. I remember I stood first in the SSC board in English language, and my teacher used to tell me throughout that my SSC year that you have got the flair for English, so keep working hard at that. So apart from reading textbook, of course, I kept improving my linguistic skills, written as well as spoken, by reading continuously outside the curriculum, extracurricular reading. And that actually the habit, it grew on me. And then subsequently, it became a kind of, I won't say obsession, but a great attraction for me that my pastime was spent in reading. So there were Shakespearean plays, there were novels. I think I must have mentioned to you in the classroom about Jane Austen and Pride and Prejudice.
Yes, you have.
Remember? Yeah. So I have been telling all my students and subsequent batches after you that the lawyers must read history and literature. This also I must have.
Yes.
And when students ask me, so where to start? So I said, start with Jane Austen, with Pride and Prejudice, that too. Because that book it transcends through the ages.
Yes, absolutely.
It doesn't have a contemporary kind of appeal. It transcends through the ages.
Yes.
And a few years ago, I read in the newspaper that a researcher conducted a survey sort of, through questionnaire, across the universities in the world, English-speaking students, that is, and asked them their favorite book, and majority of them mentioned Pride and Prejudice.
Yes.
A book which was written 200 years ago. So you can imagine the lasting and eternal allure of that book.
Yes.
Across the ages. So this was, in short, my way of improving my language. And to be able to write fluently and write effectively with precise choice of words, you have to read extensively. So I've been telling my students that please read wide and deep.
Right.
Reading wide and deep. This is really going to enrich not only your language, but your thought process. And that refinement, the erudition, and the discernment, they all come through this kind of reading.
Yes. Wow. Okay. Sir, so moving on, you are a teacher at Symbiosis Law School and you were at ILS too. Have you taught at ILS as well?
Yeah, while I was doing my LLB, perhaps the ILS faculty and the staff thought that, well, I'm worthy of delivering guest lectures for my own batchmates and some other juniors. So as a student,
Nice.
So as a student in those 3 years in the law school at ILS Law College, yes, I did conduct lectures.
So currently you're a teacher at Symbiosis Law School, Pune, and you teach criminal law. So as a teacher, as someone who is in the business of academia, what do you think about the caliber of legal education that is dispensed to law students all over the country, not just Symbiosis College, but in general? What do you have to say about the practical application that law students so need? Is that requirement being met adequately? What do you think about that?
Okay. Now, let us split your question into two parts. I think the first part was about the overall caliber and the quality of education across the country.
Yes.
Right? Okay. We'll come to practical application subsequently. Well, I haven't been exposed to law schools across the border in the country. I had the privilege to study in ILS and then, of course, Symbi for my graduation, post-graduation, and now for doctoral study, of course. That is one institution, my alma mater. Then I had a good fortune to visit National Law University, Delhi. And I spent a week there. Then also I was lucky to visit NLU in Ahmedabad. not NLU, what is called GNLU, Gujarat National Law
GNLU, yes.
University, GNLU. So I also had an occasion to spend another week there. So these two eminent law schools I have visited. Other than that, I haven't had a chance to visit other premier law schools in the country. So I haven't been able to talk about them. Now, as far as Symbiosis, ILS, and these two universities I have visited, well, they really impart quality education, no doubt about it. ILS as well as Symbiosis, and I'm proud to be an ILS alumnus as well as a Symbiosis alumnus. You see, the fountain of knowledge is there, is flowing all the time. It is up to the students to make use of that fountain.
Right.
Now, as they say that at the fountain of knowledge, some students just take a sip. Some others take a gulp. And those few who really drink at the fount of knowledge. So, it is primarily up to the students to make use of this fount of knowledge. Now, coming to the two NLUs, Delhi and, you see, there will be a definite distinction between the government-funded institutions and private institutions.
Yes.
Because of the funding restraints and because of the location itself.
Right.
New Delhi being a place where you are exposed to maximum knowledge, experience, by virtue of it being a seat of the apex court of the country. Plus the premier institutions like ILI and Bar Council of India's office, their libraries, and the exposure of the students to eminent jurists and lawyers on a regular basis. So that kind of exposure, Symbiosis does offer.
True.
Does offer to our students. We are very keen on inviting eminent jurists and lawyers and speakers to address our students on a regular basis. So on that count, our students are fortunate, symbians that is.
Yes.
ILS also invites such speakers. GNLU also, I had the chance to attend a course on military law. And they are also quite adept at inviting eminent speakers all across the world. So what, in general, I find that these law schools to which I was exposed, they are some of the premier institutions in the country, and they are imparting top-class legal education to our students. Now, coming to practical application of what the students learn, I find that Symbiosis is trying to impart more and more practical education to our students by having regular moods, which ILS also has and other institutions also have. But one aspect of the courtroom skills and the courtroom craft, which unfortunately we are not able to impart our students in Symbiosis, perhaps because of the language barrier. Because, as you are aware, at the provincial judiciary, the language of the court is the local language of the state.
Right, correct.
So the courtroom proceedings go on in Marathi here. So the evidence recording, the testimonies of the witnesses, everything will be in vernacular.
Right.
So students are not able to comprehend. So that is one drawback. But in ILS, of course, we try to expose the students to the courtroom craft. When I did my LLB, that time we studied the procedural law in the final year. Third year, that is, in a 3-year course.
Yes.
But now, of course, I think the curriculum and the syllabi, they are changing. And now students are exposed to procedural law in the 3rd year of a 5-year course, I suppose, and the 1st year of a 3-year course. To my mind, it seems that the procedural law should be kept for the final year.
Okay.
Of course, the thinking on the part of those who designed the curriculum is that in the final year, the entire focus should be on practical training and
Right.
virtually no classroom teaching. Fine.
But
And yet, I find that procedural law needs a certain kind of maturity to understand. And it should go hand in hand with the courtroom exposure of the students, so that what they learn in the classroom, they can see it being applied or operational in the courtroom. I'm of firm opinion that right from first year of a 3-year course and a second or third year of the 5-year course, if we put a focus on the practical application by more and more exposure to the courtroom proceedings, so by the time the students learn the theoretical aspects of CRPC or CPC, they are already exposed
right.
to the
Correct.
practical aspect because they have seen it, how the procedure is being applied.
Yes.
Now, if you have seen a defense lawyer objecting to the post-mortem report or cross-examining the witnesses, the students already know when they study the evidence law or the procedural law. Yes, because their mind has already been impressed with what they have seen. And the mental picture remains with the student. So the students are actually seeing in the book what they have already seen in the
Right.
court.
Right.
So I think if that is possible, combining the procedural law in the courtroom and the classroom, that would deliver great results.
Sir, absolutely rightly said. The more you're exposed to the courtroom, so later when you study what happens, it's like a revision. What you study, it reinforces what you experience in the court. Absolutely fine. So what I wanted to ask you was, you get that kind of an experience in the courtroom only during internships, right? So what do you think, what makes a good track record of internships? Should it be, suppose I am a student and I know for a fact that I want to pursue criminal law. So do I consistently take criminal law internships or internships at trial courts where I witness the proceedings and I intern under a lawyer, or do I write research papers, which is again a time consuming endeavor? What do I do? How do you hone your skills in the field that you want to excel in? What is the technique? How do you do it? Especially in 5 years, where you have a month and a half of vacation. So there's just that finite amount of free time where you can kind of, build up your skills. The rest of the time we're in college, we're in class throughout the day, that we're tired. So how do you manage that, sir? What do you think? How should students manage their time?
Well, my suggestion to the students would be that do not focus only on one particular subject during your undergraduate years.
Okay.
It is perfectly normal, natural to like a particular subject and to feel inclined towards choosing that subject and focusing only on that, even during internship. But to have an all-round knowledge of the legal profession at the undergraduate level, all subjects are important.
Right.
So you must devote your attention to all of them equally. Even during internship, it is fine to do one particular internship of 3 weeks or so in the subject of your choice. But that should not be at the expense of other subjects, because at that level, undergraduate level, exposure to various subjects during your internship is very important.
Right.
So do not prematurely try to specialize or focus only on one subject. As you are finishing your graduation, by then you have a fairly good idea as to which branch of law you want to focus on in your practice.
Right.
And this advice will be equally applicable to the students who are joining the law firms also. It's not just for the students who are going to join the practice right away. but even those who wish to join a law firm, they should also get exposed in the law firm to various disciplines. And as you spend a couple of years of your practical life after graduation, you will be really getting a good idea as to where you are inclined, actually. So let's not only say that, okay, I want to focus on civil law, I want to focus on arbitration, and I want to focus on criminal law at the undergraduate level. Have a good grounding in all these major branches of law. And then by and by, you can focus on that area of interest. Now, as far as writing research papers, which you asked, whether it is one of the gimmicks or whether one of the means to improve your skills in that particular time. Well, it differs from student to student. Some students would prefer to spend their time in writing research paper in order to expand their knowledge of that particular law, reading, analyzing what others have been saying, and then expressing opinion. Fine. But for some, it may not suit. So for those who are inclined towards more of practical exposure, studying under a lawyer, an eminent lawyer, learning from that lawyer's experience, assisting in drafting, pleading, backroom work, either with an individual practitioner or with a law firm, fine. That is up to them. So both these streams of acquisition of knowledge are equal in importance and application. How much weightage should be given to either of these two? That is a pure personal choice of that individual.
Okay.
Yeah.
So what choice would you make? I mean, had you been a law student?
I more focused on the practical aspect.
Right.
And during LLB also, I used to be working, I used to work with lawyers, criminal lawyers especially. And then during our LLM, we had a compulsory internship program during between the two semesters. So I did my internship with an eminent criminal lawyer in Pune. So that was my approach.
So thank you for that. I wanted to ask you, sir, when you were just starting out in your career as a lawyer, during your internships and your early career, what are some interesting milestones or some interesting moments that you witnessed on court? What are the top three probably?
Oh yeah. My experience is mostly restricted to the Sessions Court.
Right.
In Pune. And there is a place called Satara.
Yes.
About 120 kilometers south of Pune.
Yes.
And then there is another place called Baramati. It's about 100 kilometers from Pune in a different direction.
Okay.
So these three Sessions Courts I visited with the lawyer with whom I was interning. I remember during my final year of LLB, we had this compulsory journal writing and witnessing a criminal trial.
Okay.
So I witnessed a trial, and I think I must have mentioned this in the classroom also. It was that notorious Naina Pujari rape and murder trial. She was a software engineer in Pune, and then subsequently all those things happened to her. So we are students of law. We witnessed for 3 consecutive days the recording of evidence. And in that, the public prosecutor, special public prosecutor, had listed about 72 witnesses in the charge sheet. So I asked her, sir, are we going to call all of them? He said, no. Once we are satisfied that we have succeeded in establishing our case beyond reasonable doubt, then we'll close our evidence.
Mm-hmm.
So one of the witnesses was, I think it was the police inspector, the IO, etc. And although he answered some of the questions to the satisfaction of the public prosecutor, but he fumbled on a couple of questions.
Okay.
So here I found that skill of examination in chief by the public prosecutor who was my teacher. And he tried to guide him towards the correct answer without appearing very obvious, of course.
Mm-hmm.
Otherwise, the defense lawyer would object.
Yes.
And then he got the answers to the satisfaction, and it was taken on record.
Mm-hmm.
So that was one aspect I found quite interesting and educative also, that in a courtroom craft, how to help your witness without being very obvious.
Mm-hmm.
And another incident with the same teacher, public prosecutor, who is a defense lawyer normally, but he was appointed as a SPP in this case. During the flow of cross-examination, after a particular question, when he got the answer from the witness, he stopped there abruptly. We were all surprised because we expected him to continue the way it was going ahead. So it ended. The proceedings were adjourned for the next day. And as we left the courtroom, all of us, the students, were curious as to why he stopped. So he said, "Gentlemen, if you had watched the effect of answer of that question on the judge, you would have also realized that that is the point to stop."
Oh.
Because I wanted to get out of the witness in my cross-examination and create an impact on the judge, which I succeeded. Now, any more further questioning would dilute that impact.
Yes. Yes. Okay.
So this is the practical aspect which you learn, which you can't read, which you can't learn from a textbook.
Exactly. Correct.
Which you can't learn in a classroom. So this was quite an interesting experience and a learning experience for me. Yeah. Another interesting experience was in that Sessions Court in Satara, another murder trial. And it was mostly in favor of prosecution. The evidence was overwhelmingly in the favor of prosecution. But my teacher, he built the defense in a very ingenious way. And we were hoping that it will create some impact on the judge. And we might, just might, an outside chance, secure an acquittal.
Sorry, sir, can you come again?
Yeah.
I didn't hear you. Could you just repeat that again?
He developed the defense.
Okay.
Yeah, against odds. Because the prosecution case was really strong.
Right.
And with the defense, we were hoping an outside chance of gaining an acquittal. And that day it was posted for closing arguments. And my teacher as a defense lawyer, he argued continuously for 7 hours.
My God.
We began at about 11 o'clock. And he finished at 6 o'clock.
Okay. Wow.
With mandatory breaks in between, short breaks. But that day I learned that what kind of mental focus and what kind of physical stamina are required to be a champion defense lawyer.
Yes.
And it was really, really fascinating watching him argue with the same vigor with the same passion throughout his discourse of 7 hours. So that was quite an interesting spectacle, I must say. And I learned a lot from my teacher there in the courtroom that day.
That they certainly don't teach you that in the classroom, sir. Thank you for that.
And one more, I will quote what he told me and all of us. One of the secrets of success of a champion criminal lawyer. He said that a good criminal lawyer needs 2 things. One is ice on his head.
One is ice on?
On his head.
Okay. Ice on head.
That means he has to keep his cool no matter what.
Yes.
Ice on his head.
Right.
And sugar on his tongue.
Oh, okay. Be sweet. Pleasant disposition.
You have to be very polite and very civil and gentlemanly in your discourse. No matter what the provocation from the opposing side.
Right.
No matter how the judge is inclined in questioning you. What is the judge's disposition? No matter. You must not lose your cool and you must always be civil and polite.
That
2 things a criminal lawyer must remember all the time.
That's certainly a tip for the hot-headed readers of this magazine. Wow. Sir, so thank you for that. Moving on. So this question is, it's very topical and I have a personal relationship with this question. So I'm asking you a purely selfish question, very honestly. In the light of the recent Vikas Dubey encounter in UP, the supposed there are a lot of diverging opinions about the supposed police vigilantism, and everyone, even though the more sensible ones of us are condemning the act because the police obviously can't take the law in their hands, there is a cognitive distortion when it comes to this, because there are usually the mass appeal is that the public is enjoying it. They celebrate when the police takes the law into their hands as regards criminals and rapists, as was seen in the December Priyanka Reddy rape case as well. The 4 accused were, what was done to them. They were shot. So, sir, and I'd be lying as a law student, even I was not appalled at it. I was also slightly happy that, okay, which is the wrong feeling to have, because nobody can take the law into their hands. So for impressionable people, for young people who are going through the newspapers and they feel happy about this, so how should these instances be viewed when it comes to these police encounters, these fake encounters? How do you process such a situation when for a layman, for someone who's reading the newspaper?
Yes. Let us first distinguish between Priyanka Reddy case and Vikas Dubey case.
Yes.
Priyanka Reddy's alleged rapist murderers.
Yes.
They had become sensationally notorious overnight. And the entire country is wrath against those 4 accused.
Correct.
And it was as if the entire country had convicted them without trial.
Right.
Part of it is because of the wide coverage in the media. People keep track of everything that is said or shown in the print or in the electronic media. And then they have their own inferences and conclusions that yes, they must have done it. And then a certain amount of public rage is building in the mind of the public.
Correct.
And if you remember, around the same time, December 2019, those 4 Nirbhaya convicts in Delhi, as their death sentence was being debated in the court and the deadline was approaching, the defense lawyer on behalf of those 4 in Delhi kept on filing different petitions using the legal process available to the accused. Now, contrast these 2 things. In Delhi, that kind of a thing happening, repeated petitions, and in here, a brutal rape and murder of a young girl, innocent girl, took place in Hyderabad. So as if this was a running show for the public, that what is happening in the legal system in the country, that despite having been convicted, despite having their petition being denied, rejected number of times, our review, curative, mercy petitions, still they were not actually hanged. They kept on filing petitions, permitted by law, of course. So an impression was being created that our criminal law justice system is not able to deliver. And by that, the public opinion was that deliver means deliver justice in time.
Yes.
Because we are all aware justice delayed is justice denied.
Absolutely.
Contrary to that, there is another famous quote called justice hurried is justice buried.
Okay, yes.
That means the criminal justice system must strike a balance between these 2 extremes. Most of the people, even the jurists, they were of the opinion that in Delhi perhaps it is taking too long for the matter to be brought to its logical conclusion.
Right.
So this scenario was playing in the background, and this tragedy in Hyderabad happened. And when the police took these 4 accused for recreating the scene of the crime, and then as per the police version, they tried to escape, they snatched a weapon, they shot at the policemen, and so in defense the police had to shoot all of them and kill them. Fine. The question is, why did public react the way it reacted? You remember those scenes of public garlanding the police officers?
Yes, yes.
Distributing sweets? What does it say? The public is not to be blamed. If you remember in my criminal procedure code class, I had mentioned that the police are the gate to the criminal justice system. They are the frontage.
Yes.
They are the frontage. For a layman, for an ordinary person or citizen of this country, criminal justice starts with the police.
Yes.
Judiciary is further removed from police.
Yes.
And many a time you will find that the cases are withdrawn, compromised, settled at the police station level itself. So, in the mind of the lay public, police are, if not the important, one of the important arms of criminal justice system. And for a layman or a laywoman, a lay person, who administers the justice is immaterial. If police can give me justice, fair enough.
Right.
I don't have to go to the court. And especially with the Indian court system, we all know how much it is burdened with pending cases and backlog.
Yes. And even more so now because of the pandemic.
And I remember Justice Y.V. Chandrachud, he was the former Chief Justice of India.
Yes.
In mid-80s. He retired in 1985. He said that the criminal justice system is going to collapse under its own weight because of massive backlog. And he mentioned a figure almost to the tune of 30 million cases pending in those days. 3 crores, yeah. At various levels of judicial fora, starting from the trial up to the apex court. And cases taking 20 years, 15 years to get resolved or justice being served. Now, this creates an impression in the mind of the public that courts are inefficient in delivering justice.
Right.
Because for a victim of a crime, the justice should come within reasonable time. Now, it's difficult to define what is reasonable. You can't really put a time range on this. But even a layperson understands what is a reasonable time. Now, in the last few years, with the world coming together through the electronic media and internet, people are aware how the criminal cases are decided, how much time it takes in other jurisdictions beyond the boundaries of the country. Yes. So they compare. That is
naturally. Yes.
So with this thing playing in Delhi and this thing happening, and I was telling you that even the public believes that police can deliver justice. Why wait for the courts? In the mind of the public, these 4 accused who had committed a terrible crime, they deserve to die. Just as in Nirbhaya case in Delhi. There was a massive public support for the death penalty.
Yes.
For these four. And they wanted them to be executed at the earliest. At the earliest, by that I mean at the earliest, the way the justice system caters for. Even that did not happen. So with that background, the public opinion had already formed that these 4 must die.
Yes.
Through the agency of the state. And they must die at the earliest. Now, I don't know what behind the scenes activities must have taken place. So many versions are going on. But there were some politicians also expressing opinion about these incidents. Now, actually, when the encounter took place, the facts, we never know what actually happened. But the reaction in support of the police, it speaks volumes.
Yes.
About the deplorable state of criminal justice system in our country, in the mind of the public. And therefore, the public supported the police, saying that you delivered justice to the soul of the departed, as well as to the next of kin of that victim. So that was your Hyderabad encounter. Lawyers, law students, other jurists also, they will condemn this extrajudicial killing. Some people will go to the extent of calling it a murder by the police. Even that word is used in the case of Vikas Dubey also.
Yes.
So, if we scratch the veneer of the public reaction and try to delve deeper into the psyche of the public, you will come up with these answers. Now, can you blame the police in Hyderabad encounter? You will agree with me when I say that sometimes even the police are under pressure. It could be public pressure. It could be political pressure. Police are public servants.
Correct.
They are susceptible. They are amenable. They are prone to some kind of pressure at some point of time. So that is the result of this kind of pressures from the public or from other agencies, which police are forced to act quickly, and they must be seen to be acting by the public. So with that background, I think Hyderabad encounter took place. There will be inquiries, number of inquiries, investigations, judicial bodies, We don't know really what will be the outcome of all this. Whether a agency or a person will be pinpointed and blamed for this encounter, we don't know. Or whether everybody will be given a clean check, we really don't. Now coming to Kanpur episode, Hyderabad, your
UP.
Vikas Dubey episode in Kanpur, just 3 days ago. You are aware about the facts of that, whatever has appeared in the newspaper.
Yes.
Now, I am all quoting this from the newspaper reports, of course, because there is no other source of knowledge.
Correct.
Whatever appears in the print media, because I prefer to read newspaper rather than watch TV news.
Okay.
Because words are very powerful. And they remain with you.
True.
And you can refer back to it whenever you want. So I'm just quoting from whatever appeared in the newspaper. The saga started exactly on 3rd of July, if you remember, a week before Dubey's alleged encounter. And just to rephrase the facts, the police team went to his village to arrest him at about post midnight. And then they were ambushed, guerrilla style. They were fired at from different directions. 8 policemen, including 3 officers and inspector, they died. Now, what story has appeared in the newspaper is that the leader of the team, I think he was some deputy superintendent of police, Sharma or something, I don't recollect his name, Mishra, the leader of the team, on 3rd of July. It was Mishra, deputy superintendent of police.
Yes.
Now, the newspaper reports say that he was brutally killed. He was axed and then shot.
Okay.
These are some of the facts reported in the newspaper. And then plus there was some police mole who alerted Dubey and his gang that a police raid is coming and he is likely to be arrested. So when this carnage took place in that village Bikru, next day, what was the reaction by the police? The immediate reaction was to find out the moles, who informed him and who is likely and who fled from the scene. They mentioned one name of the sub-inspector also in the newspaper. He absconded and then I think he was recently taken into custody. Now, the next day, the police took the bulldozers and razed that house of Vikas Dubey in that village. First thing. Now you see the police reaction. The word vendetta is written clearly on this action. It was just the beginning. And in 4-5 succeeding days, number of his acolytes, Vikas Dubey's acolytes, were shot dead at different places in encounters. 2 of them at least I remember. In a similar fashion. One of them was taken into custody and the police claimed that he was being taken to the court or to the police station.
Yes.
And en route, the vehicle developed a flat tire, the police vehicle. And taking advantage of the opportunity, the accused tried to flee, snatching a weapon, opening a fire, and then he had to be killed. Something similar which is being claimed in Dubey's case. So likewise, about 5 of them have been shot, dead, taken to custody, etc. This is going on. Now yesterday, the day before yesterday's newspaper, I think a very senior police officer from UP police said that you can't threaten police, you can't kill policemen. What does it mean? That means in this particular incident, when policemen got killed, the police will take revenge. Keeping this in mind, for the entire week what was going on, according to the newspapers. In Ujjain. Reporters claim that it was a stage-managed arrest. Some claim it was a surrender. One fact reported in the newspaper was, I don't know how many of you have read it. Normally, what is the procedure when a criminal is arrested outside the jurisdiction of a police station? When the local police arrest the suspect and they hand over the custody to the police in whose jurisdiction crime was committed, they take the accused to the magistrate, the local magistrate, for a transit remand. It is a kind of legal authorization by the judiciary because of the requirement of CRPC that the accused must be produced before the magistrate within 24 hours from arrest. The magistrate will authorize the transit passage of the accused. That was not done in this case. And I think the Ujjain police, as reported by the newspapers, saying that he will be produced before the magistrate there, where they are taking him. So there was no custody, there was no transit remand, a procedural lacuna. Another thing, there were about a convoy of 60 vehicles carrying journalists trailing the 3-car convoy of the policemen, taking Dubey with them. And around 6:30 or so in the morning, I suppose near the toll plaza, the entire contingent of journalists was stopped and other vehicles, saying that we want to check your papers. Police have given their reasons why they stopped the convoy. And after stopping the convoy and the 3 police vehicles proceeded, within 15 minutes, I think the encounter took place. They claim that suddenly a herd of cattle came across the vehicle. And the driver had to brake suddenly and violently. It was raining in the morning there, so the road was slippery. With these 2 factors, slippery road and sudden braking, the vehicle toppled over.
Yes.
And then Dubey tried to escape, jumped out, took a weapon, shot at 4 policemen, the bullets grazed the chest of these policemen. And then 4 shots were fired at him and he was killed. He was taken to the hospital, but the hospital said he is brought in dead. This is a saga. But then there are lots of doubts being raised by even retired police officers about this whole episode, about this whole encounter. Let us not prejudge.
Okay. Yeah.
As to what must have happened, what is the truth, who is telling the truth, who is lying, etc., etc. There is no point unless we have all the facts and the evidence to be taken on record. But then the whole question that arises is, why is it happening? Let us say, for the sake of argument, I'm not blaming the police. I'm not convicting them at this stage. I have no right to.
Yes.
And it's too premature. Too premature. But let us say, as we say, arguendo, for the sake of argument, assuming that the police have done it deliberately, we have to again go deeper into this problem. Why? Why have the police done it, if they have really done it deliberately? Again, we come to the same problem. Even the police seem to have lost faith in criminal justice system.
Okay.
Now, as I said, they are bent on revenge. And revenge is a natural emotion.
Yes.
A natural emotion of the victim. Take any person who has been harmed through no fault of his. The first thing is revenge. That, like Immanuel Kant used to say, just deserts. To punish is the moral duty. Why punish? Because punishment is a moral duty. What comes out of it, whether it is reformation or a deterrence or a prevention, is immaterial. According to Kant, the only thing which justifies punishment is it's a moral duty. Retribution is the word at times they use it, which is for revenge, which is not revenge actually. Retribution is more of a reprobation. Society's disapproval
Yes.
of that accused or of that suspect who has harmed an innocent member of the society. So there is a natural reaction. Then some jurists also question that you say that there is no deterrence, no punished debtors, there is no vengeance. Punishment should not be vengeful. But if you see, vengeance is the basis for every punishment. Why should the convict be incarcerated in the prison? Don't you want him to suffer? By snatching away, depriving of his liberty. So these are the philosophical considerations behind the reaction of a victim. Police are also humans. They are also part of the society. They are law enforcers, agreed. But primarily they are members of the society. They are part of the society. They have come from the society. Can you put them in a bubble, isolate them, and treat them to a totally different standard? I'm using the word deliberately different standard because, yes, police are accountable because by virtue of their job,
Profession.
by duty, by the position they are occupying, they are held to a higher standard of accountability. But still, we must consider that they are also part of our society. They are also human beings. So certain feeling of revenge is bound to surface. So this is one of the reasons why the police have acted the way they have acted. And secondly, as I said, that this faith, the trust, the confidence in the criminal justice system, which will deliver the victim justice in reasonable time. That faith is getting eroded day by day, unfortunately, I must say. So the corrective action starts at the root. The policymakers and the eminent jurists and the powers that be must address this problem at the root itself. It will take time. It will take time. It's not a magic potion or a magic wand which will cure the malady in a jiffy. No. But there must be a concerted, channelized and a guided effort to address this problem. And we will see the results down the line after a few months, after a few years. But this cancer, this malady, has to be cured by attacking its root cause.
Very correctly said, sir. I completely agree with what you say. Be that as it may, like you said, we have to go to the root cause, and the baton is really in the policymakers' hands, and they have to bring about a change for there to be any change at all. But that, it looks like that's going to take some time. So in the meanwhile, how do these policemen, who are the gatekeepers of justice, as you said, is it right for them to act on their revenge? How right, or where does the moral compass veer when they decide to act on this feeling of retribution, which is not wrong again, but how does that play into the larger system?
I understand. Well, to be able to control this feeling of vendetta, one needs the training of the mind, psychological training. But even you will find in the Western countries, despite psychological advice being available to the policemen all the time, they are being exposed to this training of the mind, control, self-restraint. Still, police excesses do take place. And I'll quote that famous or notorious George Floyd police killing in where was that? It was in Chicago or somewhere. I think.
Yes, yes.
Somewhere. One of the states in USA. Last month, you must be aware.
Yes.
You see?
I'm not sure about the state, but yeah, I'm aware.
8 minutes 42 seconds. That was the duration
During which?
for which the accused was held under the knee of the policeman.
Yes.
Despite his plea that I can't breathe. And he died due to suffocation. Police excess. People in USA are claiming it is murder straight away.
Yes.
And it's a racially motivated murder and all that. Let's not go into that. So my point is that in that heat of the moment, it takes great self-control and self-restraint by the policeman to curb his feelings, to control that sense of power which he has been invested with by law. Well, he is empowered. Now, whether to use it or not, for that he needs a cool mind, a cool head, which may not be possible in the heat of the battle, in the heat of the moment. So, we try to train the policemen to exercise self-control.
So does that happen? Are the policemen in India psychologically trained?
I'm not aware about that. If it is happening, it is well and good. But if it is not happening, then the government must ensure that a police psychologist is available and who regularly gives a sort of a therapy. I'm not saying that police are mentally disturbed, but the kind of violence they are exposed to day in and day out, the kind of criminals they have to deal with day in and day out, even a sane person will become destabilized. And the police will view the whole world through that prism of criminality. In one of my lectures, I had mentioned that criminal law says innocent until proved guilty. But the policemen have a different approach. They have, in their mind, everybody is a suspect, unless proved otherwise. Because that is the basis for investigation.
Yes.
So they have to look at everyone with suspicion and then rule them out. With this mindset, the police will never view the public with a clean slate, thinking that he is innocent. No. The first thing that he is a suspect, it is quite likely that he must have done it. So this prism, which is there in the minds of the policemen, is going to affect, and it does affect, their day-to-day dealings with the public. You might have experienced or not, but when a complainant goes to the police station, even the complainant is viewed with suspicion. And that is normal. That is normal. Because many a time, the person who has committed the crime, he or she goes to the police station to lodge a complaint. And I have seen murderers, after having committed the murder and dispose of the body, they go to the police station and say that I want to lodge a complaint, so and so person is missing. So the point is, the police will view everything and everybody with suspicion. In such a scenario, when they are given the powers, especially to use the weapon, it's very, very difficult to curb that urge to use that power.
Right.
Especially when there are certain antecedents, like in Vikas Dubey. It is illegal. If it has happened, it is illegal. Even if the police have killed an encounter, everybody will start questioning to the each and every antecedent of that encounter as to what happened. Was it possible for that person to flee? He is a middle-aged man with a huge paunch. Vikas Dubey I'm talking about.
Yes.
Could he really manage to escape from that toppled vehicle? And all those details will emerge gradually. Now, speaking of theory, when we discuss any situation theoretically or academically, we are in a different frame of mind. But when an incident happens to us means the people who are discussing it academically are members of the society, then our thinking changes. We are not that rational, that dispassionate, that neutral.
As we'd like us.
Otherwise, we were in an academic discussion. So our discussion, our approach gets hued, tinted by these incidents which has happened. A classic example is when the abolitionists of death penalty, they discuss abolition in theory. They have a different approach. But if something sinister happens to an abolitionist, then his approach will change. And he does change. And I'm quoting this from a famous case law, Bachan Singh versus State of Punjab. Rare surrender principle.
Yes.
You remember 1982 SCC 684 is the citation.
I didn't remember the citation, sir.
For your readers and viewers, in case they want to check the case law, I'm mentioning the citation. That judgment mentions this aspect, how the topic changes or the approach changes in a theoretical setting and when in a practical setting. So bringing that analogy to our point, our problem on hand, discussing encounters in a sterile, theoretical and a peaceful surrounding is totally different from when you are involved in such a kind of an episode.
Correct.
They say always step into the shoes of the accused and get into his mind and try to think what he must have thought. Let's make an attempt to step into the shoes of the policeman who actually carried out the encounter. And remember, there were a number of policemen there.
Yes.
Including officers and other ranks, and everybody was there. Now, at times a question arises. In both the encounters, Hyderabad Priyanka Reddy as well as Vikas Dubey, was there any support from the higher authorities to this encounter? And will the policemen be able to carry out such an encounter unless there is a tacit approval of someone? That is the big question. Policemen on the ground, they will carry out the encounters. But step into their shoes and try to imagine what they must have thought, what they must have been thinking since 3rd of July, when 8 of their men were brutally killed. And not by any other person, but a notorious gangster who was wanted in number of criminal cases. So that changes the situation completely. So again, the distinction between Priyanka Reddy and Vikas Dubey. Priyanka was an innocent young girl who was full of life and whole life lay ahead of her. And a life snuffed out prematurely in a brutal way. Contrast Priyanka Reddy with Vikas Dubey. Still, no condonation of Dubey's encounter, but still if you're going to make a comparison, a relative analysis, pluses and minuses, there may be a slight mitigation in Dubey's encounter.
Right. Right.
It depends on subjective view, of course.
Yes.
Everything is subjective.
Yes.
Ms. Trishala, I must say this, you will agree with me. Everything is subjective.
Yes.
No matter how hard one tries to be objective. The person claims to be objective, but a subtle element of subjectivity is always there in all decision making. And that is the basis of discretion. Discretion, after all, is what? Subjectivity is bound to creep in. And to give a classic example is that the NLU Delhi did a survey of 60 retired Supreme Court judges on death penalty.
Okay.
and rarest of rare principle. Is it really applied, properly applied, etc.,
Yes.
etc. So many of them were of the opinion that yes, death penalty should be there, it should be given, etc., and ROR principle is being applied, but the judges do stray away from that, etc. One judge, he said that even rarest of rare is subjective.
Okay.
So, despite all those elaborate guidelines in Bachchan Singh judgment given by a 5-judge bench, constitutional bench, the subjectivity could not be eliminated in subsequent decisions. And the learned judge said that many a time the judge has already decided either to confirm the death sentence or commute the death sentence. And having decided either way, now the judge is going to find the justification from the available facts. This thinking process is exactly opposite of what is recommended. You analyze the facts, you see the aggravating, mitigating factors, and then you decide whether it is rarest of rare or not. Not the other way around.
Right.
You decide first, this is rarest of rare. And then you start, or this is not rarest of rare, and then you start finding the reason. This is subjectivity. So you really cannot subjectivity from any decisions, especially discretionary decision. Subjectivity is an integral part of judicial discretion.
Correct. Very true, sir. Very true. Complicated processes of our country. What can we do? Sir, moving. Yeah.
In reference to what you said, a complicated situation in our country, but same situation to a more or less extent exists in other countries also.
Yes, sir, it's correct. That's right. But there are things there, even though they're complicated, there are more expedient ways to counter those complications. Now, for example, you spoke about the guidelines in Bachchan Singh about the rarest of rare principle. Until you said it, I thought all the subjectivity was kind of zeroed in those guidelines, so that there is no outside scope. This is as subjective as it gets. But turns out it gets more convoluted as more kinds of horrendous incidents happen. So it's like listening to, okay, Nirbhaya case, the Priyanka Reddy case are one of the worst, most heinous. The description of those, the facts were the worst I've ever heard. So would we have to wait for a more horrendous situation to occur, God forbid, for us to again modify the rarest of rare principle, for it to incorporate that kind of brutality also? So it broadens your scope, but then it's so disheartening to know that you have to wait for more. There is more to happen.
Unfortunately, the Bachchan judgment refused to box in the judicial discretion.
Okay.
They said they are just guidelines. They are not mandatory.
Yes.
A judge has to use his discretion. Now, this has left a widest possible scope for the judge to decide, for the reasons earlier I gave you. You see, the movement all over the world is away from death penalty. Amongst the democracies who still have death sentence on the statute book, US is of course there, India is another, and Japan. But there is a vast number of difference between the number of executions that take place in USA and in India and Japan. Japan, I suppose, last year executed one person. In India, before the Nirbhaya convicts hanging on 20th of March 2020, all the three in immediate past, all the three executions were related to terrorism offense. Three ones. Yaqub Memon in 2015, Afzal Guru in 2013, and Kasab, the Pakistani terrorist, in 2011. Prior to that, the last person to be executed, to be actually executed for rape and murder, was Dhananjay Chatterjee.
Okay.
In 2004. So you see, from 2004 to 2020, 16 years had passed without a rapist murderer being actually executed. And if you see the NCRB statistics in these last 16 years, many rapist murderers were actually sentenced to death. Their sentences were confirmed and affirmed by the Supreme Court, still not executed. Some of their petitions were pending before the president for mercy petition under executive clemency. Some of the sentences were commuted by the president. Bottom line is, till 2020, in the previous 16 years, no rapist murderer was actually executed. Despite the fact that brutal, heinous, gruesome, dastardly, diabolical, and revolting rape murders did take place. And Machi Singh judgment, 3 years, which came out 3 years after Bachchan judgment, that is 1983, 3 SCC 470. That judgment also mentions these adjectives, where the collective conscience of the society will expect the holders of the powers of judicial center to meet the cry of justice of the society by imposing death sentence, irrespective of the fact whether the judge believes in death penalty or not. This is objectivity in decision making. Not done. So point is that the rapes and murders will continue to take place. Even as we are talking, perhaps some rapes and murders taking place in this country. But the judicial thinking has now come to this level not to impose death sentence, even on a rapist murderer. Nirbhaya case was exceptional on 2 counts. One was the extreme brutality, but having said that, doesn't extreme brutality take place elsewhere? In fact, brutality is inherent in rape.
Yes.
And yet, we talk of extreme brutality. The adjective extreme is used in Nirbhaya's case. That execution those executions were carried out because of 2 things, as I said. One was that brutality, and the entire episode, the facts of the case were simply revolting. And secondly, a massive public opinion. If you remember those peaceful rallies and demonstrations by massive crowds in Delhi, post the incidents on 16th of December 2012, it went on and on and on. So massive public opinion. That was a contributing factor in ensuring that those convicts are hanged. I pray to God that this doesn't happen again in this country. This kind of beastliness and savagery and brutality. But it did happen to some extent in case of Priyanka Reddy. And I remember, post Nirbhaya tragedy, there were copycat attacks
Oh my
in different
God.
places in our country. Different places in our country. Now, what does it tell you or tell us? No matter how people are convinced, learned juries, that this is not deterrent, this is pure retribution, death penalty I'm talking about. It has no reformative value. It has no deterrent value either. So then what is deterring these people? Nothing. Even a lifelong incarceration in prison is not going to deter them. So in this connection, eminent jurists of the past, in the 80s and 90s, they have said that death penalty is one which is the limit. And how many potential murderers, you can't obtain the statistics. Because they are potential murderers. We really don't know. Now, statistics alone, that people are not deterred with death penalty. Statistics alone doesn't prove the point. Crime against women and children, they are rising exponentially. Daily you will find in the newspaper. So what is the cure? What is the remedy for this? Speedy, effective and speedy investigation, day-to-day trial proceedings, and curtailing the time lag that is involved from the trial court judgment and the final confirmation by the appellate courts of the sentence. These are the only ways to ensure disposal of the cases. And apart from that, it is said, one of the principles of penology is that in order to be effective, the punishment has to have three attributes. They're all three C's: celerity, severity, and certainty.
So could you back up severity? What is the second one?
Certainty and celerity.
Okay.
Celerity.
Okay. Okay. What does that mean, sir?
Celerity means swiftness. Swift. So, if the state wants a punishment to be effective, to have an effective deterrent value on the society, that punishment must be seen to be certain and quick and severe, which doesn't happen in our country. Now, in case of death penalty, only one S is satisfied, that is severity. It is severe, all right. Is it quick? Is it swift? Is death penalty swift? No. It takes years. Is it certain?
No.
Death penalty is not certain. So on these counts, the death penalty flops. It falls flat on its face to be effective as a deterrent. So the thinking is that remove it from the statute book. Let us abolish death penalty. But the policymakers are not in favor of abolishing it. In the post-independence era, from 1947 onwards, in last 70 years, 4 times an attempt was made in the parliament to bring a motion to abolish death penalty. Each time it got defeated. Now, last time in 1978, the motion was passed in Rajya Sabha, but Lok Sabha never took it, and the legislation lapsed. So, the political thinking on this issue is, let us keep the death penalty on the statute book. and let judiciary decide whether to use it or not. So as a result of that, the judiciary is splitting its hair where to use and where not to use. Majority of the opinion is now against rarest of rare principle for its inconsistent application. So the thinking is that do away with rarest of rare. Okay, do away with it. What is the next benchmark then? What is the substitute? There is no answer so far. So what I find is gradually we are moving towards the abolition of death penalty. Judiciary has de facto abolished. There is another landmark judgment of 2009, Santosh Kumar Bariyar versus State of Maharashtra. In the Bariyar judgment, the bench laid down that out of those number of mitigating factors in Bachan Singh, number 3 and 4 are to be strictly applied. And they are that the prosecution must bring evidence on record that the convict cannot be rehabilitated, cannot be reformed. Now it's a very difficult task and a tall order from the prosecution to gather an evidence to predict a future event. To give an example, what is the guarantee that a person who has so far not committed any crime will not commit a crime in future? Can you guarantee?
No.
There is no guarantee. So similarly, a person who has committed a crime, heinous, serious, brutal crime, what is the guarantee that he won't commit a crime again? In other words, based on the current available evidence, the prosecution is made to predict about the future conduct of the accused. Now, this is a very onerous and difficult task. So, with the result, death penalty is de facto abolished. If the prosecution cannot bring the evidence that the person cannot be reformed, in other words, there is every possibility that he will be reformed, no death sentence. That is the approach now. So, I very much doubt whether the kind of incidences that we are discussing, Delhi and Hyderabad, whether we can prevent them. Punishment doesn't act as a deterrent, no matter what.
Right. Thank you, sir. Thank you for that. So, speaking of the holes in the criminal justice system, recently there was an article in the newspaper about the Union Home Ministry installing a committee for criminal law reform, and it has been criticized because the committee itself consists of a few male Delhi-based lawyers, and there is no adequate representation of women, not just apart from it's just men, so obviously no women are being represented, also no people of various social standings. So plus it has been criticized because of the time in which it has been installed, because it is in the midst of the pandemic, where and they're deciding to take consultations online, but it is being severely everyone's very skeptical of the results, because the mandate is also apparently very vague. They are saying that the view of this committee is to install provisions that are, to uphold the dignity of the victim and their, individual worth, and there is no specific streamlined mandate as such. So what do you have to say about that? This particular committee that has been installed and has started work on reforming the criminal law provisions.
Well, to tell you the truth, I haven't read anything about it.
Mm-hmm.
You mentioned it has come in the newspapers.
Yes, yes, the Hindu.
Can you just briefly tell me when did it appear?
So the
Date? Any
first
idea?
that I read about it was on July 4th. So that's when it said that the Union Home Ministry has installed the Criminal Law Reform Committee, and it has the committee consists of so and so a
Mm-hmm.
few lawyers, male lawyers in Delhi, and with a view to find out ways, provisions to expedite the criminal justice system, to kind of well oil it and make it efficient and expedited. And the mandate, it's extremely broad. It's not at all classified, it's very broad, which is why it came under the scanner. Another reason was underrepresentation. Another reason was that there is no clarity on what they want to aim. And especially another criticism was the timing in the midst of the pandemic. So in the light of what you said, the kind of the shortcomings of the criminal justice system, there are these attempts being made to kind of streamline it with the situation of the country, with the already complicated process that is there in our country, to simplify it, to expedite, to make it efficient. And yet it's the traction, it's not attracting traction, it's not for the right reasons. So why do you think that is, and what should be done in the context of criminal reform committees of
So
such type?
if it is a criminal justice administration reform,
Mm-hmm.
then we are on a different platform. If it is criminal law reform, then we are talking about something else.
Criminal law reform, sir.
A law reform. Yeah, okay. Well, I wish it had been criminal justice reform,
Okay.
because the problem that are plaguing the criminal justice system, they have to be handled first,
Mm-hmm.
which I've been discussing all this while.
Yes.
Problems faced by the criminal justice system. So actually that should have been accorded a priority rather than reforming criminal law.
Mm-hmm.
But anyway, from whatever you told me and the specifics that you quoted here, let's come to the timing of this exercise. In the absence of full disclosure of the information as to why this timing was chosen, we are simply in a manner conjecturing and guessing as to what must be the reason. About the appropriateness of time or inappropriateness, let's not go into it. One possible reason could be of course, the Dubey encounter took place on 10th of July. But Dubey's attempted arrest took place on 3rd of July. And you said it appeared on 4th of July.
Yes,
committee
the
formation
first that I read of it, it was on
So
the
if the
4th of July.
timeline, So if the timeline is accepted and agreeable, then in that case we can put 2 and 2 together as to the immediate trigger for formation of this kind of committee. Why it was formed post haste on an emergency basis, and why now? Especially pandemic, and when there are problems, when people can't meet in person, because technology has its own limitations. So why now? So one possible reason, if it fits with the timeline, could be the Bikru carnage of those 8 policemen and number of them wounded. Also in the aftermath of that, and even earlier to that, there has been a constantly raised voice about the politicians, criminals and policemen nexus, even before the Bikru carnage. So in order to deal with this issue, and now matters have come to head really with the Dubey incidents, when the police officers were pinpointed, so and so is the mole, so and so informed Dubey, so and so fled from the scene without opening fire. So there were a concrete evidence now. So this matter has come to an head. So therefore, this could be the immediate trigger to constitute a committee to suggest criminal law reforms. We still don't know their mandate in detail, their brief as to what exactly they're expected to do. Are they going to suggest to overhaul the entire CRPC in 1973? Are they going to suggest amendments to IPC 1860? Are they going to recommend amendments to Evidence Act 1872? We don't know really what kind of exercise they have undertaken on a massive scale or on a very limited scale. In your information, has the committee been given a deadline to submit the report?
No, sir. I didn't read anything that says.
Right. Okay. Okay. Fine. So there is no time pressure. Fine. As it stands now. Now coming to the composition of the committee. Are these lawyers, are they all from Supreme Court? Senior advocates?
Yes, I think so, sir. One of them is Mahesh Deshpande.
Okay. Okay.
Yeah.
Fine.
But many Supreme Court advocates and judges and female lawyers, one of them is Indra Jaising, they have all collectively written a letter complaining about the lack of representation. So I don't know how that is. Maybe, yeah.
You mean Justice Indra Jaising?
Yes.
She has been elevated to the bench or no? No, not yet.
No, sir.
Okay.
No.
She is a senior advocate there.
Hmm.
Okay. Okay. Right. Yes. They have a point here that if the panel selectively has included only male lawyers, that of certain seniority, fine, seniority I can accept as a qualifying criteria. But then there are equally senior lady lawyers in Supreme Court. So why they are not included? I'm not in a position to say anything in this respect as to what must be the objective purpose behind the government to exclude women lawyers. Because it doesn't stand to reason why they have been selectively excluded. Now coming to their task. Now I'm just put forwarding my views in the absence of any concrete facts. If they really want to reform, which again should be a part of reformation of criminal justice system, they must handle CRPC on top priority. CRPC is a very good document. It confers powers on the police, powers on the judiciary, and yet there is a balance, check and counter check, between these two agencies of the state. But the focus, the crux, and the drive should be aimed at expediting criminal justice administration. That is what is ailing our system, the inordinate delay. It's exasperating for the litigants.
Yes.
The justice administration process just doesn't seem to come to an end. It goes on and on and on. To give you an example, even in the Supreme Court, when the bench gives the decision, there is a provision for petition. There is another provision for review petition. So it goes on endlessly.
Yes.
Now take the case of death penalty. If death sentence confirmed by the Supreme Court, Now, when the executive rejects the petition, clemency petition, the convict comes back to Supreme Court or High Court with some other issue. This serves no purpose. It doesn't serve the interests of the criminal justice system. It must come to an end. And the procedural law must draw a line. This much and not beyond. If this is what they are having in their mind when they talk of reformation, then yes, I'm all for it. And they should expedite this process. If they are going to suggest alterations to IPC, well, they can very well do it. As you are aware, 377 has been struck down.
Yes, yes.
They should remove it. They should repeal it. The parliament must do it.
So sorry, could you just repeat that section again? Your video was blurred.
377.
Yes, yes.
Unnatural Act 377 of IPC, which has been struck down by the Supreme Court as unconstitutional. But still, it continues to be on the statute book. And it should be repealed by the parliament.
Yes.
Another section is 494, adultery. That also continues to be on the book. So these kind of reforms are required. I don't know about other section, how much they are going to suggest changes to that or amend those sections.
Right.
But I would request, in my humble opinion, the committee to focus on expediting the administration of criminal justice. Expediting must have learned about the of 2003, the Mallimath Committee report.
Yes.
About reformation of criminal justice. That report was never implemented.
Yes.
Perhaps it was found controversial. But we have a report with us, although it is now 17 years old. It is time to refer to that report and pick up those things which suit us in today's times. We have a reference there in Mallimath. So again, I would request the committee to refer to the Mallimath Committee report, which will help them perhaps in their task of suggesting reforms to the criminal law and criminal justice system, especially. Recommended little wider powers to the police during investigation. He has suggested a major reform that do away with Section 20 Evidence Act. Section 21 Evidence Act says that confession made to a police officer is not admissible. Code of law. So, Mallimath Committee had recommended remove Section 25. You are tying the policeman's hands. They get the confession, but it can't be used in the court. So the committee had cited its own reasons as to why 25 should be done away with. But these are the things, just one example I have given you, which is really retarding the speed of investigation.
Right.
So if the backlog has to be cleared, criminal cases backlog has to be cleared, we have to find ways and means on various fronts and inject a fresh thinking into looking at the existing laws. 1872, the British rulers had some reason to drop Section 24 Evidence Act. Perhaps they were foreigners and they were not sure how the policemen will use this power to them against the natives of this country. Could be a reason. Now, situation has changed. Will the same constitution of 1872 apply in 2020? Obviously, it won't. So we have to bring a fresh thinking into overhauling the system completely. So on that count, I think the committee should be well armed to carry out the task. As far as composition, of course, they must have a relook at it and make it a more broad-based, neutral composition.
Right, right. Sir, I think your video has paused. Okay. So can you say something?
Okay. Yeah.
Yeah.
No. I
Okay.
paused. Yeah. I stopped. Yeah.
Yes, now it's fine. Okay, sir, thank you so much for that wonderful insight. Lastly, last question. We've come to the end of our interview. What are your 2 cents to law students, any students for that matter? Because I think everyone has something to learn from you and your experience. So, what are your words of advice?
Oh. Well, it puts me in a bit of a quandary because today's students are well informed and they will become knowledgeable from being well informed to be knowledgeable through a consistent effort. Information available at the disposal must be applied judiciously and sagaciously, but must make an attempt right from beginning. Simply gathering information will not lead to knowledge. Its application is very important.
Yes.
I will repeat my advice which I uttered in the earlier part of the interview to all the students. Read history and read literature. The students.
So, what are your top 5 books that you would recommend for a student who's just beginning, who wants to read history, literature?
Okay, fine. History, I really cannot recommend one single book. As you are aware, history is such a thing.
Yes.
So you'll have to refer to a number of books. Pick any history book from an authentic publisher, but read about Indian history, about English history, about legal history subsequently. But reading English history is very important.
Right.
Literature, I will recommend wide reading, as I said, across the genres, fiction, non-fiction. From fiction, students must read Shakespeare. For 2 reasons. One is that Shakespeare's language 400 years ago, it might sound archaic today. It is difficult to comprehend. But then you will have aids to understand the language, but once you read that, you will understand the depth of thought of Shakespeare, his characters and his plots across various plays. So reading Shakespeare for its sheer literary value. And number 2, there is a lot of criminality involved in Shakespeare.
Yes. Full of it.
If you just have a cursory look at Hamlet, Othello, Macbeth, and Julius Caesar, to mention a few, they all have murders. There is a murder that has taken place, and there is an avenger. So the criminality in Shakespeare is worth studying. And mind you, Shakespeare was not a lawyer by training, but his knowledge of law is on display in his famous play, Merchant of Venice.
Yes.
And the students will learn a lot about contract law if they read Merchant of Venice and the arguments advanced by Portia, the accused lawyer, Bassanio's lawyer.
Yes.
So read Shakespeare for the language, for the characterizations and the criminality. That is as far as plays are concerned. Julius is, of course, one must read for Mark Antony's speech at Caesar's funeral. An excellent piece of literature. And one must read Jane Austen, as I had mentioned. Very important from language point of view, and the subtle nuances of human nature in a different setting, of course, compared to Shakespeare. Jane Austen, different era, different setting, different genre. But one must read Jane Austen. One must read Bond novels. May not be of top quality literary value, but our students will gain a lot. The way the plot develops, the language of Ian Fleming, and the sheer thrill going on. Even in James Bond novels, in portraying this protagonist Bond and his lady love, there are subtle threads of emotions described by Ian Fleming. So it's not all just for action. No. There are human.
Yes.
Therefore, read James Bond novels. And then lastly, I would recommend 2 books by an author called Ayn Rand. Some of the students might have heard about her. Ayn Rand was a Russian-born naturalized American. And she was born in 1905, and she witnessed the Soviet Communist Revolution, Bolshevik Revolution, at a tender age of 12. And then having seen the fallout of that Communist Revolution and its regime, she fled to USA and then settled there without having any support there on her own. And she became a famous novelist. And she wrote 2 philosophical novels. She wrote many more, but 2 are worth mentioning. One is Fountainhead, and Atlas Shrugged.
Atlas Shrugged, yes.
Atlas, a famous Greek from Greek mythology. Atlas, he is expected to bear the burden of the entire earth on his shoulders.
Yes.
So imagine what will happen if he shrugs the shoulders. That is the topic of that book, Atlas Shrugged.
Yes.
And it's an allegory, actually. It's an allegory.
Yes.
Allegory is an extended metaphor. So you can take it as a metaphor as well, an analogy. So she has compared Atlas, the Greek hero, a massive giant, with the intellectual giants of the modern world, who are carrying the weight of this earth on their shoulders in modern times.
Wow.
And just as the mythological hero was abused, similarly, the modern intellectual heroes are being abused by the modern world. That is the plot.
Okay. Wow.
So read Fountainhead first, in which she has propounded the philosophy of objectivism. You will come to know what objectivism. I will not waste your time in explaining to you what is objectivism. And as a follow-up of that book, in fact, she calls it, she gives a metaphor of orchestra between these 2 books. She says if Atlas Shrugged, it was a prelude, Fountainhead was a prelude to a symphony, and this is the main theme. Atlas Shrugged is the main Both the books have got tremendous on great proportions, and each one of them has got tremendous depth. Language is difficult, but one must focus and understand. Not to be read lightly, both these books. It has to be taken seriously, read properly, with focus, and take number of months, doesn't matter. It will not be finished in a 1 month also. But once you finish that book, you will like to reread it again and again, again and again. That is the unending allure of that book, both the books. So read Shakespeare, at least those 4 plays which I have mentioned. Read Jane Austen's Pride and Prejudice. Read Bond. And then finally read Ayn Rand. A-Y-N, Ayn, R-A-N-D, Rand. Rand.
Yes. Yes, sir.
So I think this should arm my students and those listeners who are not my students with adequate knowledge of language, logical thinking, and critical analysis. Very important for the lawyers.
Right. Right. Thank you. Thank you, sir. Thank you so much for this. This was a wonderful session. And thank you for taking out so much time to sit, to be here and to answer all my questions. Thank you, sir, so much.
Thank you so much. It was my pleasure.